Good morning, everyone. Welcome you to the meeting of the Hart County Board of Elections and Registration. Thank you all for taking the time to come. This meeting is not a normal meeting of the board. This meeting is for the purpose of a hearing. Based on information provided to the Board of Elections and confirmation of that information, I hereby challenge the candidacy of Michael Rumsey as a write-in candidate for the position of on the board of on the Bowersville Town Council, specifically as to whether he has met legal obligations under Georgia law to have his votes counted. At this time, I'd like to turn the meeting over to Walter to conduct said hearing.
Let me establish a couple of ground rules to start with. We will hear from anyone that you want us to hear from, okay? The way we'll do this first is that I'll make a case. And then, and you will have the opportunity to ask questions to anybody that I ask questions of. And I anticipate that is only gonna be Ms. Webb. You will then have an opportunity to present any witnesses you have, and I may cross-examine them, or you may make whatever statement you wish to make. At the conclusion of that, then this board will make a determination. And let me say at the outset, sir, that this board doesn't make the laws of elections in Georgia. It's the state of Georgia. Yes. Through the General Assembly. They make the laws. This board has to simply comply with the laws, and it has to avoid being challenged itself. And any elector in any election can file a challenge to any candidate or any procedure should they have grounds to do so. And what has been alleged, as you've heard, is that you did not make the qualifying notice to the Board of Registrars and Elections, nor did you file that the notice in the newspaper. The relevant law, I have prepared a copy for you, and at this point, do you anticipate you'll have anybody other than you to testify or to talk?
Maybe Jeff and Mr. Nolan.
All right, well, anybody who then might be testifying, I want you to raise your hands, please. That'll include you, Robert. Me too. Do you so solemnly swear that the testimony you'll deliver on the issue pending in this hearing will be the truth, the whole truth, and nothing but the truth? Yes. You say, I do, or I affirm?
Yes, sir.
I do.
All right, thank you. All right, each of you are under oath. Please keep that in mind as you begin your testimony. I will call Ms. Robin Webb. Can you tell us your name?
Robin Webb, Elections Coordinator, Hart County Board of Elections and
Okay.
Registration.
How long, you know how long you've been doing that, Robin?
I have been with Hart County 4.5 years.
And prior to that, you were with another government, were you not?
5 years.
Okay. In the same, similar type of position?
Voter registration.
Okay. Robin, or Ms. Webb, does the Hart County Board of Registration and Elections, do they handle or conduct the Bowersville town elections?
Yes, sir. We have an IGA with Bowersville.
An IGA being an intergovernmental agreement.
Yes, sir.
And does that agreement provide that the Board of Registrars the Hart County Board will make determinations in the event of election contest, that they will also qualify voters to vote in the election, and that they will operate the election, count the votes, etc. Does it?
Yes,
So it's a complete turnkey operation then?
it is.
All right. Do you remember when, or the date on which the qualifying period for candidacy to the Bowersville Town Council, when did that period expire?
August the 21st.
All right. And did you, I believe did it start on August 19th?
Yes, sir.
Okay. So it expired August 21st, and that's 2019, right?
Yes, sir.
Okay. Now, 7 days after that, help me calculate that. I'm not the best in math, but I believe that 7 days later would be on or about August the 28th of 2019. Is that right?
Yes.
Okay. Now, has Mr. Michael Rumsey filed with the Board of Elections a written notice of his intent to be a candidate by write-in in the Bowersville town election?
No, sir.
All right, has Mr. Rumsey or someone acting on his behalf given any intent, or provided you with any intent to be a candidate in the Bowersville city election? Do you, have you been informed that Mr. Rumsey has filed any such notice with the town of Bowersville, with its clerk or administration?
No, sir.
Okay. Now, do you typically monitor the Hartwell Sun for, around elections, when, notices involving election?
Yes, sir.
And you did that this year?
Yes, sir.
Did you find, any evidence of a notice of intent of candidacy filed by Mr. Rumsey in the Hartwell Sun
No, sir.
anytime this year?
No, sir.
Okay. Now, did you, notify Mr. Rumsey of the date and time of this hearing?
I did.
And did you also provide him with basically a summary of the basis of the complaint?
Yes, sir.
Okay. I have no further questions. Whatever questions you want to ask her, you may.
I don't have any other than if I would've known, I would've done it. Like I said, you know, the townspeople did it, it wasn't me that done it. The townspeople wants me to.
Let me now, go into a brief period where, I will point to the specific and appropriate Georgia law. The Elections Code in the state of Georgia is generally Title 21, and Title 21, Section 2, Article 133 is the relevant law today. That law, and I'll read selected portions of it, and I've got another one other copy should anybody want it, and I provided Mr. Rumsey with one. Long and short is, it starts off saying, no person elected on a write-in vote shall be eligible to hold office unless notice of his or her intention of candidacy was filed and published, and then I'm gonna skip the part for state and federal elections, and it goes to no later than 7 days after the close of the municipal qualifying period for municipal elections. It also cites in Part A3, in a municipal general or special election, notice shall be filed with the superintendent and published in the official gazette of the municipality holding the election. Unless there's been a newspaper crop up in the last few days, I believe that would be the Hartwell Sun. Then, Section B provides, in addition to that a write-in candidate shall also file a copy of the notice as published with an affidavit stating that the notice has been published, including the name of the newspaper, the date of publication, no later than the 5th day after the deadline for filing and publishing such a notice. That is what I find to be the relevant law. There's one other section of the Georgia Election Code which I will cite because I think it has a great deal to do with why we're here. And that is in Title 21, Chapter 2, Article 494, 21-2, 494, the Official Code of Georgia. It's headed Computation and Certification of Write-in Votes. And what it says is that the superintendent, and we're talking about the election superintendent there, in computing the votes cast at any election, shall compute and certify only those write-in votes cast for candidates who have given proper notice of intent to be write-in candidates pursuant to Code Section 21-2-133, which is what we just read, exactly as such names were written by the electorate. And let me go ahead and say that I think if you thought about that, you realize that that does not prohibit your candidacy, sir. You know, you can run all you want to.
Yes, sir.
But what it does prohibit is this body's ability to count your votes.
Yes, sir.
It's very clear There have been several, cases that have traveled through the appellate courts of Georgia, which have upheld that rule and said that it didn't matter how many votes may have been cast for the write-in candidate. There are really two relevant things. One was the name exactly as it was on the, notice? In other words, did he use a middle initial or a middle name or something like that, which is a ticky rule. I don't like it, but that's what the rule is. You know, if you filed, say, for example, as Michael J. Rumsey, everybody had to vote for Michael J. Rumsey, or it wouldn't count. The other thing that has to be done is that you have to file the notice of candidacy with the Board of Elections and run the notice in the newspaper, in the Hartsville Sun, and then provide an affidavit to that effect. And, having said that, I don't believe I have any other questions. I'll turn it over to you, sir.
I don't have really any questions, you know, other than, like I said, you know, I feel honored that the town wants me, you know, in there. If I'd have known, I would've done it, you know, I didn't know, I mean.
I understand and completely, you know, there's, a lot of people understand that they don't know the law. A lot of people think they do, even when they don't.
Right.
You know, the law in the state of Georgia consists of 58 or 60 books about this size. And I will tell you, I am the first one to admit that I don't know all of the law either, and nobody really can. Nobody can be expected to. But that said, even when the law has a harsh result, the law has to be followed. And that's the situation we have here. As I said, if they find that your candidacy was not authorized or that you're not qualified as a candidate, that means your votes can't be counted. Now, it doesn't mean that you have to stop your race. You can, but it's kind of, I would leave it up to you to make a decision as to whether or not that would be fair to the people of Bowersville to hold yourself out as candidate. So with that said, do you have anything else that you want to say, or any other witnesses that you want to put up, or have anybody else talk on your behalf?
Unless Mr. Nolan or Jeff has something to say, I am kind of curious as to who complained.
The complaint was actually made by the elections board itself, based on the fact that there was no notice filed here, and that there was no, notice that was, at least no notice seen in the Hartsville Sun, and no notice provided to the board that the notice was published in the Hartsville Sun.
And if I decide to keep going like I'm going, would my votes be seen?
Would they be
Per
voted?
se, would they be seen, like how many people actually did vote for me?
That's a good question. What the rule says is that the superintendent, in computing the votes cast at any election, shall compute and certify only those write-in votes cast for candidates who've given proper notice of intent. What that means is they really can't count your votes. Now, I presume that if the board so desired, they might voluntarily count them, you know, and of course you are, permitted to be a part of the counting process. You could see it, you can attend the counting and see the counting going on and keep a record of your own. But I do not believe that under the law that they can, and this is carefully worded, they cannot compute or certify. They shall compute or certify only those write-in votes cast by candidates who've given proper notice. So that means, the word compute means to me they can't count it.
They'll show, but they won't be counted.
What will happen is, if someone casts a vote for you, it will be displayed on the, or are you using machines or? Okay.
Machines, yes, sir.
It'll be full, all machines, except for maybe,
Except for
absentees.
Yes, sir.
All right, absentee ballots will have a place for a write-in, right?
Yes, sir.
And then the machines will also accommodate a write-in.
Yes, sir.
Okay. And what will happen then, and this is what always gets to be a little tricky in a when there is a write-in, campaign, as I said earlier, the name has to be exactly as it was on the nominating, on the application, the qualification document, and we don't have that. So I don't know what we would say. Your name, we know you're Michael Rumsey, so, and, you know, as far as I'm concerned, that, you know, and this is not a legal opinion, but it's, you know, you would know generally what your level of support was.
It won't be made public though.
No, we cannot compute or certify. Compute means count in this, context, and certify would mean to certify to the public at large that these are the results of the election. You know, at the end of the election, as y'all have done before, each of you will examine the returns or oversee the process of counting. And then, at the conclusion of that, there will be a document prepared that shows who got how many votes, and y'all each sign that. That is your certification of the election, and then you submit that to the Secretary of State of Georgia. Did y'all have anything that you wanted to say on his behalf, Mr. Nolan?
Two things. Three things. One, we appreciate the meeting because it gives clarity to what we're trying to do here. As residents of Bowersville, once the opposing candidate dropped out, that left only one candidate, which would make it a shoe-in. That didn't seem quite right. So we drafted Michael, and Michael accepted. And the letter of the law has not been followed as it is written. Thus, what will happen, well, let me go to the second thing. One of the most important things we get out of this is that these votes cast for Michael as valid votes should be counted. Now, if that means Michael has to be in the room, which he has the right to be, as Walter said, fine, that count can take place. I realize it's not gonna be official, but that number of votes should be made available to Michael so that it can be made public. Now, I understand it'll be published it's not official, but it will be at least made public. I think everybody understands the reason for that. You've got a candidate running for the office, his votes get counted. You got a candidate who's a write-in that the residents would like to have seated. The likelihood of that in this election is not good because of the way the law is written. So we understand that. But the number of votes that Michael J. Rumsey receives should be available and made public, even if it has to be made public by Michael. The other thing is, at some point in time, I'm not sure how we will do it, but the election code 212-494 should be challenged. Walter, you heard me say this many times, always work within the system, but make it strain every time you use it. All right, we're making it strain. If it's broken, we'll fix it. If it's not broken, we move on. So certify only those votes cast for candidates who have given proper notice or intent to be write-in candidates pursuant to the code section 212-133. Understand that, that's the law. We all follow the law or we get in trouble. So that particular code section, 21-2-494, will be challenged. And it's not challenging the validity of it, it's challenging the structure. All the votes should be counted. Even if Mickey Mouse gets one vote as a write-in, it should be counted and reported. Now, certified is another thing, but that's the intent here. Two intents. Make sure that the number of votes cast write-in for Michael Rumsey get counted and reported in some way.
They can't count them, George.
Okay, let me restate
They
that.
can disclose the result of the machine, okay?
Right,
That would be a public act.
okay, well, let me restate it, Walter. If you're not gonna count them, but Michael is in the room where they are tallied, then that tally,
They won't be tallied, George. They will not be counted. Now, and I don't wanna put too fine of a point on it, but I think you understand, when it says that they're not to be computed, that they're not to be counted. may have a difference with that law, and I'm not gonna ask you to disclose your grounds, because that's up to you. If you're thinking in terms of attacking the constitutionality of this statute, which is typically the way you would handle a challenge to a state law, you would file suit and seek to have a declaratory judgment that the law was unconstitutional. I think that in all candor, and I appreciate anybody who wants to test the law and to stretch it, as you said, or strain it, as you put it, because that is how things get done sometimes. I will advise you that this law has been in the law of the state of Georgia since the Code of Georgia was assembled and published in 1933. That was when it was put into the Georgia law. That was then codified in 1964, which is when the state of Georgia, kind of set up all the laws in the current form, the codification, and that the law has been challenged. The most recent challenge to it was in 2006 in the case of Brody versus Champion, and in that case, the Georgia Supreme Court, all the cases involving constitutionality, of course, go to the Georgia Supreme Court. They don't go to the Court of Appeals. That's just an aside. But the Georgia Supreme Court found that 21-494 was constitutional, despite the challenger's claim that it impermissibly allowed the exclusion of votes for write-in candidates. And in that particular case, there were 9 write-in votes cast for individuals, but none of them had given any intent of their candidacy. The real issue is whether or not voters are disenfranchised, because everybody, the right to vote is one of our most fundamental and most sacred rights that we have. And a participatory democracy is just that. It is where the people express their desire. That desire then becomes known or counted and qualified, certified, and then things happen as a result of that. So the right to vote is critically important. There have been so many times where elections have ridden on one vote. The one that I remember most vividly, because I was involved in the campaign, was the presidential race between Richard Nixon and Hubert Humphrey. If Hubert Humphrey had gotten one more vote in every precinct in the country, that'd be a tall order. But if he had gotten one more vote, only one, in every precinct in the country, he would have been the president of the United States. And there are many others like that. There are some stories revolving around Abraham Lincoln and others who, but for one vote, might have prevailed. We had one here. It seems like Hart County has some of the strangest things I've ever seen, and has things happen the first time that I've ever seen it happen, and that's exactly what happened back in the late 80s, I believe it was. There was an election for District 4 of the Hart County Board of Commissioners, and the result was what we call a dead heat. There were 3 people in the race. The ultimate winner was I can't remember his name right now, but the ultimate winner had exactly 50% of the votes, which means that the other 2 people in the race had the very same number of votes put together. If there were like 494 votes on this side, there were 494 on this side. And that's a dead heat. You can't certify that this man won, okay? And even though it's pretty clear that he almost did. And in that case, there had to be a runoff, and the fellow that came in second was most gracious and said, look, don't have another election because of me, he can have it. And he probably made a very good decision by saying that, but it still had to be, there had to be another election held. And, that one did not come out with a dead heat tie. So things do happen, and every single vote is important. And appreciate what you said, George, this board's hands are tied. But we'll be looking forward to seeing what you found, and, you know, that there'll probably be people all over the state that would be, keenly interested in such a suit.
Mr. Gordon, can I ask a couple of questions, just for educating me? Like, Mr. Rumsey or any candidate in his position, on the day the votes are counted, can they have someone accompany them as
Sure.
an observer?
Yes.
Okay, I was curious.
Isn't that right?
Yes, sir.
Mhm.
Okay, and then the other question is, and I don't know, and I ought to know, cause my wife ran for city council and won, so shame on me. When they do the posting, how to qualify,
Mhm.
are the instructions posted at City Hall on how to qualify as a write-in and in the paper?
You know, I don't know that, don't know the answer to that question. The really relevant question is the law available to everybody in the state of Georgia? And the answer to that is, yes, it is.
I got a couple of things. First of all, I found out about Michael. Michael went to pick a car up for me, and me and him was going to pick it up. And Michael come to me and he said, you know, I got people coming up to me, want to write my name in for a council. I said, well, Michael, I mean, he said, well, I think that's an honor if somebody would do that. And I said, would you accept it if that happened? And he said, well, I don't see no way I couldn't. He didn't run for this. He didn't do this. The people in the town do not like where it's going. They don't like
You know,
the
that's
capital.
what I
Hold on a
understood.
second. Hold on a minute. Let me finish. People in town don't like the way the town's going. Now, I ran for election and I won, and I'm not running again for health reasons. But Michael didn't run. The people of Byersville said, look, we don't like the candidate that's up. We want you to run. So that's the way that, and I understand there's all kind of rules of everything, but you do know history has been made here. You do know history right here is being made today. First of all, he's got to win. You got to win before you get anything. He might not even win if wrote him in and he was counted. But history's being made. It's already being told on a state level. I'm pretty sure it's going to go national.
And
I'm
what
saying,
is that?
I'm saying if he wins a write-in candidacy, it's already going state level. It's going to go national level probably if he was to win and a write-in, and then y'all not accept the votes, which I understand the rules and regulations.
It's not a matter of accepting the vote.
I understand that. Who is on the board?
The
Who
matter-
is the board here today that's going to?
These three people.
These three people. These three right here. Are you ready for the fallout that's going to happen if he was to win?
I'm gonna suggest you ignore the question. I mean, you can answer it if you want to, but you're not on the witness docket.
Well,
here.
first of all, you
If
got
you wanna
to.
explain to us
I'm just
what's
saying.
gonna happen, that's fine. You know, you can tell us whatever you want to.
I'm just saying.
But I
This,
will tell you, sir, that these votes, whether there's 1 or 10,000, these votes will not be counted if they vote this way. These votes will not be counted, nor will they be certified. And you're gonna have a hell of a time trying to, file a lawsuit based on that.
I didn't say nothing about a lawsuit.
Okay.
Walter, I didn't say one thing about a lawsuit. I have not said one thing. All I've said is, first of all, first of all, even if it was county, he's got to win first. And y'all know that's a long shot. But I'm just saying, if enough people in Byersville thinks that he should go in office and he gets wrote in and he gets in there, then it's gonna go. It's just his history being made.
Well, I would agree that if, enough people vote him in, and then somehow he is certified to hold the office, that would be history making, because it would be a violation of the state law. And then what would happen is I'd be defending these three folks in Hart County at the taxpayer's expense against a lawsuit that would be filed by the state elections board, where the board would be represented by the Attorney General of Georgia. So it would be a history making thing.
Mr. Gordon, can I ask one more question? Again, I'm just trying to educate myself. I'm not, say Mr. Rumsey counts his votes and he did get the most, okay? And then the guy that's officially the candidate does the right thing with his integrity and said, undoubtedly the town doesn't want me. I'm gonna withdraw my candidacy. But then there be a special election?
Have to be.
Okay, that's all I was curious
Now, I'm
about.
assuming that this one is a regular election, right? Okay. It would have to be a special
There be a
election.
time limit
because-
on it, or
A
there's so
time
many
limit on-
days, like another one?
Yeah, there would be, it's not necessarily a time limit on the election itself, but it would be a matter of following the Georgia law that would be applicable in the circumstance. which would be basically the same as any other candidacy that was abruptly vacated.
Yes.
Like, you know, there've been cases where, not here fortunately, but there've been cases where someone was elected and then died before they took office,
Absolutely.
you know, 3 months later or 2 months later. And so that kind of thing does happen, but the remedy provided by Georgia law is a special election. And those special elections have specific deadlines, and I couldn't tell you, I mean, I
That's
can
fine.
find
I'm
them
just
out, but I
curious.
couldn't really tell you what they are. But it would probably be something that would happen within a month or two,
Yes, sir.
maybe.
Thank you, I appreciate that.
Now, Walter, going back and letting me finish what I started,
Sure.
we got off into a history lesson there. Let me go also into a history lesson. When I say that the challenge of the election code 21-2-494 doesn't necessarily have to wind up as a legal battle. All of us respect the law, all of us respect the way the Constitution has set us up to operate. But the law is tenuous sometimes. And if you watch the legislative process, you'll know how tenuous it is. I was present when the Speaker of the House once said, yeah, I know the law, Tom Murphy, and I loved him to
Imagine
death,
that.
loved it to death. He said, I know that law is not right, but pass it anyway, we'll fix it in the courts.
I've heard that.
And that was, and what I'm referring to, Walter, and you will remember this, most of the people in this room won't know it, but I'm talking about Gennaro Wilson in Douglas County. Sent to prison for 10 years for statutory rape. Judge had no choice. He had to do it because that's the way the law was written. He followed the law. That's what we all do. But in this case, as it was in that criminal case, the law is just a little bit out of step for the 21st century. So it needs a look. Now, as I said, filing a challenge doesn't necessarily mean legality of it. It can go through the legislative process to be changed. And that's what we're doing here.
Mhm.
There's a section that is a bit fractured and needs to be addressed by the legislature. That's a major part of why we're in this room today.
Well, you realize, of course, that, George, that this body is not the General Assembly, and this body has no ability to change the law even if they wanted to. But you're on the right track if you want to go to the Georgia General Assembly and seek redress there.
All politics is local. That's where it all starts and it moves
Well,
on.
unfortunately, in this circumstance, while all politics is local, laws governing elections in the state of Georgia are determined by the Georgia General Assembly as a whole.
We're aware of that.
Any other thing anybody wants to say?
Yes, I would like to say that Michael Rums is a fine person,
Absolutely.
and speaking for everybody here and the whole of the city of Bowersville, if Michael were to get elected, then he would be a good candidate, and I have encouraged him to run even for mayor. And I think Michael would be a fine, a candidate for either council or mayor. I just wanted to let everybody know how I felt about that. As far as the elections go, you gotta follow the policies and the rules.
You know, and that's, I certainly don't know anything negative about Mr. Rumsey. He seemed like a nice man to me and somebody who may very well be a good councilman, or other town officer. You know, what we're looking at here is what it is. And unfortunately, I don't know of anything that would allow or authorize this board to spurn the law or cast it aside for any reason. And even if they all believed it was unconstitutional, they can't. That's the rule of law that operates in this country. The rule of law is sacrosanct. And particularly in this day and time, when we see people from the very higher levels of government ignoring the law or making fun of it, it's something that we all need to think about, because the law is, the rule of law is what keeps us together as a country, as a state, and as a town. And politics has become so much more fractured over the last, 20 years. You know, I remember a time when politics, when a politician was a respected person. He was respected for his office, and where the political process was a respected process. And it does seem like there's been a lot of chipping away on that, over time. That's an aside, probably shouldn't have even said it. Mr. Chairman?
Yes, sir. Do we need to go ahead and vote?
If you're ready to, yes.
Okay, at this
If there's
time,
any questions y'all may have of Mr. Rumsey or Ms. Webb or anyone else.
at this time, I'd like to ask for a motion as to, whether or not to count, whether or not, Mr. Rumsey's, has met the qualifications to have his votes counted. May I have a motion, please?
I make the motion that, follow the letter of the law, can't be counted.
I agree, we have to follow what it says.
All in favor? Three, let it be recorded that the vote is 3-0. Does that conclude our?
I believe it does, unless anybody else has anything that they wanna add.
Can I say something? Mr. Ramsey, I don't, Mr. Ramsey, I don't know you, I've never had a conversation with about this issue. There's just no ambiguity there.
I understand.
I mean, you know, people can argue the intent of the Constitution all the way down. I don't know if you can argue the intent, it's just the law is the law. And I know we mentioned rules, well, this is the law, and there's just no ambiguity there. That's just.
Yeah, if I would've known, I would've done everything.
I'm sure you would have, sir.
Let me state one thing, that all of us here at this desk, the 3 more members of the board, really have no choice but to follow the law. We are all sworn to follow the laws of the state of Georgia and the United States of America. Our personal feelings don't exist. It's just a matter of following the law. Thank you very much.
Does this conclude the?
At this time, I'd like to adjourn the hearing, and thank you all for coming. Appreciate you.
And Mr. Rumsey, there'll be a letter that will be put out today to you that will recite the decision that you've just seen be made. We appreciate your attendance.
I appreciate you. Thanks, sir.